We're going to be talking in Chapter 3 about whistleblowing conflicted loyalties. That's the title of the chapter. Most employment situations are employment at will. Ordinarily, a contract of employment may be terminated in the same manner as any other contract. If it is to run for a definite period of time, the employer cannot terminate the contract at an earlier date without justification. If the employment contract does not have a definite time, it's called terminable at will, or under the employment at will doctrine, the employer has historically been allowed to terminate the employment contract at any time for any reason, or almost any reason, as we'll discuss. Gradually, federal and state statutes were enacted to provide certain individual rights to workers, protecting them from workplace exploitation and discrimination by the employer. So the rule of employment at will developed in the 19th century, and it gave employers the freedom to dismiss their employees at will for a good cause, for no cause, or even for cause morally wrong without being thereby guilty of legal wrong. This is what your book talked about. So you're going to learn about employment at will in this chapter. Employees cannot be fired as punishment for attempting to organize themselves into unions. So that is an exception to the employee at will, that you can be fired unless there's a contract for almost any reason, as I stated, but not because you're trying to join a union. Also in the 1960s, federal civil rights laws, which are called Title VII, created remedies against employers who fire workers because of their race, national origin, color, religion, sex, age, or disability. So this is another exception to employment at will. You cannot be fired because of your protected reason, including race, sex, religion, and national origin. In 2002, Congress passed corporate fraud reform legislation with whistleblower protection, protecting those who report financial misconduct in publicly traded companies. This law, known as SOX, or Sarbanes-Oxley as it was called, was strengthened and expanded after the housing crisis and an economic meltdown of 2007 to 2009 in the Dodd-Frank reform legislation. So you're actually going to learn about SOX, which is, it prohibits a publicly traded company or any agent of it from taking an adverse employment action against an employee who provides information, testifies, or otherwise assists in proceedings regarding, number 1, mail, wire, bank, or securities fraud. Number 2, any violation of an SEC or the Securities Exchange Commission rule or regulation. Or number 3, any federal law protecting shareholders against fraud. This act sets forth the types of adverse action that qualify for protection, specifically protecting employees from discharge, demotion, suspension, threats, harassment, failure to hire or fire, blacklisting, or action otherwise discriminatory against employees in their terms of conditions of employment. And as I discussed just a few minutes ago, there are exceptions to the employment at will doctrine. The Whistleblower Protection Enhancement Act, which was passed in 2012, strengthened an earlier law, the 1989 Whistleblower Protection Act, covering federal employees and protects employees who report waste, fraud, and abuse. Tort law has made some inroads into employment at will exceptions that allow plaintiffs the chance to convince a jury to award a substantial amount of monetary damages if they are wrongfully discharged. And during the past half century, most U.S. courts have come to recognize the tort of wrongful discharge, which is a firing that contradicts public policy and that undermines what is beneficial to society in general. Under SOX, senior management of publicly traded companies must individually certify the accuracy of financial information. Boards of directors have more oversight responsibilities, and internal and independent audit committees must be established. So SOX protects whistleblowers. Publicly held corporations cannot retaliate against an employee who provides information or assists in investigating conduct that the employee reasonably believes to be securities fraud. You're also going to learn about the blowing the whistle for food safety, the Food Safety Modernization Act of 2010. This was the first major overhaul of the nation's food security system in 80 years, and it authorized the FDA to require science-based safety controls of the food producers under its jurisdiction. While vegetables, fruits, nuts, dairy, and seafood are within the FDA jurisdiction, the Secretary of Agriculture controls the quality of meat, poultry, and eggs. You're going to also learn about an example of an anti-whistleblower law, which is referred to as ag-gag, which is a controversial anti-whistleblower law that makes it illegal to record undercover videos showing animal cruelty. In this chapter, you're also going to be exposed to cases that deal with public employees and the freedom of speech. And public employees are defined as those who work for the government for any of its branches. I'm a public employee because I work for a public institution, North Carolina A&T State University. But it can include police officers, air traffic controllers, and those employed by the government or supported by institutions such as hospitals or schools would be called public employees. And there are three cases that your book is going to talk about. The first is Pickering versus Board of Education. And in this case, they're all three Supreme Court cases. The Supreme Court weighed the interest of the teacher as a citizen and commenting upon matters of public concern against the interest of the state as an employer in promoting the efficiency of the public services it performs to its employees. On balance in this, Pickering's free speech interests were greater. So the court found that the plaintiff bringing the case, Pickering, the teacher, interest outweighed the school's interest. The court noted that a public employee could not be punished for speaking out on matters of public concern unless the employer could demonstrate that the employee's statements caused a substantial interference with the performance of his or her duties or with the functioning of the workplace. And in this case, it could not be shown that there was a substantial interference with the performance of the duties, Pickering's duties. And Connick versus Myers, the court, before applying the Pickering test, the balancing test, the court ruled that it would first have to determine whether a public employee's speech was related to matters of public concern, thus creating a new obstacle for plaintiffs in these types of cases dealing with freedom of speech. The third case, in Garcetti versus Ceballos, the court stated in reaching its holding, we hold that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline. So what does that mean? If I am, even though I'm a public employee, if I make a statement as a teacher and as part of my duties as a teacher related to my job, that doesn't necessarily deal with the matter of public concern. And under the Garcetti versus Ceballos standard, those statements that I made within my duties as a teacher, as within my job, would not be protected under the First Amendment. So you will also learn about the False Claims Act, the key tam whistleblowers, and those are plaintiffs who initiate claims under the False Claim Act. And it's actually what they're called. It's an abbreviation of a Latin phrase meaning who sues on behalf of the king as well as for himself. And under the 1986 amendments, key tam cases are mutually advantageous to the Justice Department, which can receive triple damages or called treble damages, and to whistleblowers who can be awarded from 15 to 25% of the amount recovered, depending on the value of the evidence they provide. I hope that you enjoy this chapter. It's very interesting.